The chaps are talking about deciphering Australia's cybersecurity laws for a safer future. That's the kind I like. So James is a principal analyst at AUSCERT. He's been working in the IT industry since 2005. His primary focus lies in cybersecurity GRC, which is complemented by a wealth of experience across various IT domains. I'll keep going. His expertise spans computer systems, IT governance, business analysis, IT consultancy, service delivery, and systems administration. This breadth of experience equips him with an interdisciplinary approach to handling tasks and cyber projects, addressing aspects concerning people, processes, and technology. James's commitment to continuous learning empowers him to navigate and excel within the ever-evolving landscape of cybersecurity. Brenton is with DDH Graham Limited. He is a cybersecurity analyst and also an experienced lawyer. This unique skill set enables him to navigate complex legal landscapes within the realm of cybersecurity with a nuanced understanding. Brenton, a proud Indigenous Papua New Guinean, adeptly combines his cyber expertise with legal acumen, ensuring comprehensive protection against digital threats while complying with stringent regulations. His multifaceted background allows for innovative problem solving, crafting robust strategies that fuse legal compliance with cutting-edge cybersecurity practices. So if you could join me in welcoming you to the stage. Thank you very much.
Thank you. We would like to acknowledge the traditional owners and their custodianship of the lands on which we meet today and pay our respect to their ancestors and their descendants. Hello everyone, I'm Brenton, a former practicing solicitor and a cybersecurity analyst now. My background is a unique fusion of cybersecurity law and economics, I should say, equipping me with the insight to effectively bridge the gap between non-technical and technical stakeholders. Today, I'm thrilled to be here with my co-presenter James to discuss cybersecurity law with you all.
Thank you, Brenton, and hello everyone. You missed one fun fact there, Brenton.
What's that?
I can introduce that if you like. So, Brenton got into cybersecurity because he struggled to abide by the law, apparently.
Thanks for throwing me under the bus, James. I've actually got some dirt on this guy as well. He used to spin decks in London and Ibiza. But apparently now he's just presenting decks.
Whilst that's true, I guess there was an introduction earlier, but I work for AUSCERT, great organisation to work for. Just shy of 20 years experience in IT. My current passion is cybersecurity GRC, and we're looking forward to unpacking cybersecurity law with you today.
Now, before we begin, everyone, we'd just like to stress that the information provided in this presentation is for informational purposes only, and it's not intended to serve as legal advice.
I'll let you clip.
So, what will you walk away with today? Today, you'll gain the following, but most importantly, you'll gain a broad understanding of the Privacy Act, the NDB scheme, and the SOCI Act. You'll learn some recent revisions and pending changes for these legislations, and we'll wrap up with a Q&A. So to set the scene and provide some context around the laws we'll be discussing today, I'd just like to paint a little picture for you. So I'd like you all to imagine it's a sunny, brisk Monday morning in Brisbane. Alex, a seasoned IT project manager in a large healthcare provider that manages extensive patient data, arrives at their office at 9 a.m, ready to start the week. As they boot up their PC, they notice an unusual slowness in the system. Eventually, the situation escalates as a SOC team confirms a data breach has occurred, identifying that personal data, including names, addresses, medical records, and billing information, has been illegally accessed and exfiltrated. A grim situation to be in. So, I'd like you to put yourself in Alex's shoes. No doubt, you'd likely be thinking, what now? Who do you call? What are the legal implications? We'll address these questions and more throughout our presentation.
Thank you, Brenton. So, before you think about calling the Ghostbusters, and we deep dive into the Privacy Act, let's actually just look at what actually information privacy is. So, like cybersecurity, privacy is everyone's business and not just the responsibility of the IT team. On screen, you'll see two important definitions of privacy, one by ISO, one by NIST. But ultimately, the goal for privacy is to safeguard personal data and ensure its confidentiality. This is a very powerful quote from Carly Khan, the OIC Privacy Commissioner. Privacy is an enabling right for a variety of other human rights. It's a very powerful quote, that. So let's use the medical, use case for that. So privacy, say, in medical records ensures individuals can seek medical care without fear that their medical information is being disclosed without their consent. So I'd like to get a raise of hands, if that's okay. When you checked in at the Star or the Gold Coast, a different hotel this last few days, can I have a raise of hands who's actually used the government-based ID when they checked in? So passport, driving license, etc. So why am I asking that? Think when you hand your ID over, is this form of ID essential? Think the principle of least ID. So by that, use the lowest form of ID the check-in process allows. So for example, for myself, when I checked in, I used my staff card. Now that's not always going to be acceptable, but I think if you can minimize your privacy footprint, the better off you will be to reduce the risk of unnecessary exposure of personal information down the track.
Thanks, James. Great tips there, mate. So everyone, in an era where data exchanges hands with little friction, the Privacy Act essentially serves as a critical barrier in protecting our personal information. So you may ask, why is the Privacy Act important? Simply put, guys, in today's digital economy, information equates to power. The Privacy Act ensures this power is not misused. The Act establishes rigorous standards for data handling, ensuring that everything from health information to our financial details remains secure and confidential. In essence, the Privacy Act plays a crucial role in balancing the needs of organizations to use our personal information for legitimate purposes, along with the individual's right to privacy. So, who is required to adhere to the Privacy Act? The Privacy Act mandates compliance from what's called APP entities. Typically, an APP entity includes a government agency or office holder at the federal level, or an organization, which can be an individual, a corporation, a partnership, unincorporated association, or a trust. Now, exclusions from being an APP entity include a small business operator with annual revenues below $3 million, except in certain cases, a registered political party, a state or territory government authority, and apparently Facebook. Nonetheless, a small business operator is considered an APP entity and must abide by the Privacy Act if they manage another business that generates $3 million or more in annual turnover, provides health services or holds health information not contained in employee records, like gyms or wellness centers, for example, collect or disclose personal information for a benefit, service, or advantage, like retail companies using loyalty programs, are a contracted service provider under a Commonwealth contract, or operate as a credit reporting body, such as Equifax Australia. The Privacy Act sets out several key obligations for entities handling personal information within Australia, I should say. Among other obligations, and central to the objectives of the Act, are the Australian Privacy Principles, otherwise known as the APPs. These 13 principles regulate the collection, use, disclosure, and storage of personal information. APP entities are bound by these principles. A detailed summary of the APPs can be found on the Australian Information Commissioner's website, but let's briefly dive into a couple of examples. So, APP 6 stipulates that an organisation may only use or disclose personal information for the purpose for which it was collected, unless, of course, consent is given for other uses or specific exceptions apply, In Alex's case, the unauthorized access and extraction of personal information indicate a failure to protect data from being used or disclosed for purposes not consented to by these individuals. Now, APP 11 essentially states that the organisation must take reasonable steps to protect the personal information they hold from misuse, interference, loss, unauthorised access, modification, or disclosure. Something which Alex's organisation failed to do, resulting in the data breach. Now, at this point, you might be thinking, what are the legal consequences of breaching APPs anyway? Well, why does this all matter? Well, firstly, individuals affected by breaches can file complaints with the OAIC, which may lead to formal investigations into the alleged non-compliance. Secondly, the OAIC can negotiate enforceable undertakings with the violating entities. And if these undertakings are breached, the OAIC can actually seek federal court orders to enforce compliance. Thirdly, and in cases of serious or repeated breaches, the OAIC can initiate legal proceedings in the federal court, which can impose substantial civil penalties on both responsible individuals as well as organisations. Lastly, and as James will cover for us next, breaches involving unauthorised access or loss of personal information might trigger obligations under the, you guessed it, Notifiable Data Breach Scheme. Over to you, James.
Thank you, Brenton. So the NDB scheme. So part of the Privacy Act, it was amendment in 2017, received royal assent that year, and then it was introduced in 2018. So under the NDB scheme, an organisation or agency must comply with Australian privacy law, and that's, let's go again. If they comply with the privacy law, so it's a government agency or organisation with what Brenton speculated earlier, they have to tell you about a data breach if it's likely to cause you serious harm. And a breach must be notified to the OIC and to the individuals affected if a reasonable person would conclude that the breach would be likely to result in serious harm to affected individuals. So when we talk about data breaches, quite often we think about the large-scale APT acts on databases, what we see in the news. But it's not always that. It could be as simple as you've got your laptop at like the start this week, and you may leave it behind. Someone takes that, the laptop's not encrypted, sensitive information is locally stored on that, on the C drive or the desktop, for example. So it could be as simple as that a breach could be. It could also be someone sending a wrong email to the wrong person with sensitive information as well. So many cases, and another one we've seen in the news last month, I think, where a technology issue caused a data breach that exposed personal information, Qantas in that case. So there's several examples there. So when to notify? So an organisation, I did ask this question to someone the other day. I said, how long do you think how long do you think they've got to actually notify you? And they said, a couple of days, something like that. I said, well, what if I told you it was 30 days not to just notify you, but actually assess? So currently, in terms of the current legislation, and we'll get to the changes shortly, there's 30 days to assess whether the data breach is likely to result in serious harm. And then notify affected individuals as soon as possible. So with regards to serious harm considerations, there is some considerations in the legislation, section 26WG. However, if in doubt, best to notify. And for Alex's case, based on the audit investigation which took place, they clearly, after complying, have to notify. So how do you notify? So on the OSC webpage, there's an HTML form, what you must fill in. However, There is a training PDF available, and I recommend getting across that and looking at that in the event your organisation does have a breach. So the benefit of that is obviously you're prepared and you've not got to go through an HTML form and keep going next. So preparation is key. So how to notify individuals. Data breach can be done via email, text message or phone call. Notification should include the organisation's or agency's name, contact details, the kind of personal information involved in the breach, a description of the data breach and recommendations for the next steps you take in response. I would imagine most of us in the room have received something similar over the last couple of years from the large data breaches which have occurred. However, if you're not able to do that, the organisation or agency must contact everyone, and if they can't do it by the other mediums, what we've just said, a notification can go on the website, or it can go through social media, news articles, or advertisements. So, long story short, somehow you've got to notify. So now we're going to go on to a few statistics. So for those that don't know, the OIC issue 2 reports a year based on data breach notifications, and we can see in this snapshot here that notifications have gone up 90% in this reporting period. And if we look at the top 5 sectors, clearly our service providers are at the top, almost double of finance, followed by, sorry, I can't see the slide there, insurance and retail, and then Australian government. So Alex's organisation was clearly at the top there and leads by quite a bit. So then when we look at the actual sources of data breaches, clearly malicious or criminal attacks were at the top at 67%, and then human error was at 30%. So we're going to have a look at what caused the human error notifications. So top 1, PI sent to the wrong recipient by email, followed by unauthorised disclosure at 20%, but then interestingly, PI sent to the wrong recipient by mail. So that's important to know that it's not actually always electronic information and electronic data breaches. It can be paper-based mediums as well. And then when we look at data breaches that resulted from cybersecurity incidents, 211 notifications received, and phishing at the top there at 28%, and compromised credentials at 27%, followed by ransomware and hacking. So some pending changes which are going to be coming. So Privacy Act review report issued February 2023 for public consultation. In September that year, comment papers were reviewed and a new report was issued. 116 recommendations reviewed. 32% agreed proposals, and then 58% proposals agreed in principle. We're going to take a look at a couple of those. But I guess what's the significance and impact? Well, it's the biggest reform of the Privacy Act since its inception, and we're expecting a draft later this year on that. So the first one, we're going to look at a few proposals. These are agreed in principle. So when we talk about agreed in principle, it means that it's not set in stone and there's going to be further consultation. But the interesting one and one of the big ones here is that we talked earlier about there being 30 days to assess. Now it's going to look like that it's going to be notify the OIC as soon as practical, but no later than 72 hours. So a massive change there. And then it's going to be possible if not all information can be provided at that single point in time, you can then drip feed that to the OIC, and then once you've notified individuals, the same can occur as well. So I think that's very welcome, that change. What can you do for now? I guess be prepared and prepare a data breach response plan. So the other one is small business exemption removal. So Brenton talked about this. So this is also agreed in principle, but that's likely going to be removed as well. Reason for change, so obviously doesn't matter depending on your turnover. You can still be trading personal information, and you can still be dealing with biometrics and other sensitive information. So that is going to come. But before that, there's going to be further engagement because that's going to be a big change for small businesses. But I guess what can you do at the moment? Well, know what data you have, where your data is, and what to do in an event. A couple of other proposals agreed in principle. Proposal for direct right of action for breaches, and proposal for invasions of privacy. So the question is, so what? Well, this means that individuals would be able to initiate class actions themselves, which is not possible today in Australia. So this is likely going to mean more class actions following data breaches, but initiated by individuals rather than consumer class actions. So, for example, if we look at the Optus case, that was Slater and Gordon. So we're going to see less of that. Individuals are going to be more empowered. So we're going to go on to the SOCI Act soon. But before that, we're just going to look at a breach case study. So this is a mid-tier law firm. Not going to name this law firm, but you probably can imagine who this is. So in this case, the incident was 4 terabytes of data exposed, affected 62 Australian government bodies, major banks, airlines, and multinational corporations, including the OIC as well, interestingly. Company response, refusal to pay the ransom. Legal injunction obtained in June 2023 to prevent the data leak. And the granting of the injunction to organisations may have limited the impact of clients according to the National Office of Cybersecurity. So, what was the consequences? So I think February this year, the OIC launched their privacy investigation on this, looking at examining the potential violations of the Privacy Act in relation also to the security and protection of the personal information which was old, but also the notification of data breach to affected individuals. So what are the lessons learned? Well, the importance of government-industry collaboration in cyber incident response, and the National Office of Cybersecurity also issuing guidelines on incidents and how to request coordinated support and the development of a playbook for future breaches, as well as a proposed cyber incident review board to share lessons and enhance public and business resilience. Over to you, Brenton.
Thank you, James. All right, everyone. Let's dive into the core of the SOCI Act, everyone's favourite act, which commenced on 11 July 2018. So, originally, this legislation covered just a handful of sectors, like water, electricity, and ports. Basic stuff, right? But following reforms, it now encompasses a wider array of sectors, including healthcare, financial services, and even higher education. Now, the Australian federal, state, and territory governments define critical infrastructure as those physical facilities, supply chains, information technologies, and communications networks, which, if destroyed, degraded, or rendered unavailable for an extended period of time, would significantly impact the social or economic well-being of the nation or affect Australia's ability to conduct national defence. So following the reforms, there are now 3 positive security obligations, otherwise known as PSOs, for critical infrastructure entities. Sorry, I should say assets in the SOCI Act. Now, firstly, the extension of the obligation to report ownership and operational information relating to critical infrastructure assets are to be included in the Register of Critical Infrastructure Assets. Quite original. Secondly, the mandatory cybersecurity incidents notification obligation, which requires critical incidents to be reported to the ACSC within 12 hours of becoming aware of the incident, and for other cybersecurity incidents to be reported within 72 hours of becoming aware of the incident. In Alex's case, the data breach was not considered critical, as there was no material disruption of the availability of essential services provided using the asset. So they had to report the incident to the ACSC within 72 hours of becoming aware of it that fateful Monday morning. Finally, an obligation on the responsible entities of certain critical infrastructure assets to adopt and maintain a risk management program, otherwise known as a CIRMP, including the regular review and updating of that program. These obligations set out in the Act are now switched on, i.e. compliance is required for relevant assets under the legislative rules, which determine which elements of the PSOs are switched on for particular types of critical infrastructure assets. So the responsibility for complying with these new obligations lie principally with either the responsible entity or direct interest holders. If that wasn't enough regulatory burden for you, the responsible entities for certain critical infrastructure assets, must also comply with ISO 27001, NIST CSF, or an equivalent standard by 18 August 2024. Mandatory obligations aside, the silver lining here is that these, standards may serve as a partial defense in potential lawsuits for torts of negligence, not to mention the boost to your organisation's cyber resiliency. So the inaugural CIRMP annual reports that must be approved by boards are due by 28th September 2024. So some important dates to remember there. If you haven't already done so, please consult your legal counsel to, clarify any definitions and requirements, determine whether your organisation is a relevant critical infrastructure asset, identify which PSOs may apply to you, and identify who the responsible entity or the direct interest holder is for your critical infrastructure asset. We also recommend embedding a clear understanding of the defined roles and reporting lines necessary to comply with any applicable PSOs into your organisation's relevant policies, such as your incident response plan, for example. Moving on now, the enhanced cybersecurity obligations detailed up here on the screen relate to systems of national significance, otherwise known as SUNs under the SOCI Act. The SOCI Act provides that the Minister may personally and privately declare a critical infrastructure asset to be declared as a SUNS.